All right, Shelby Rodriguez. All right, so today an offer is due.
Yes.
All right. All right, I'm gonna set this for a plea deadline date. And I'll set it for January 14th.
Yes, that's perfect, Judge.
All right, thank you. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Thank you, Judge.
Thank you. Roberto Andrade. Is he the iPad or is he the review a Wi-Fi?
That's a good question. Roberto Andrade, I'm not sure.
Roberto Andrade, you need to show your video.
I'm sorry?
Okay, see me.
Sorry, our camera is not working
Oh.
on the back. Are you Roberto Andrade?
Yes, ma'am.
Yes.
All right, so
Yes, that's.
uh
I can hear you.
So offer has been tendered and everything?
Yes, and so I just need some time to go over it with him.
All right, Norma, and is this, if you all reach an agreement, are you going to be asking that this be done over Zoom or not?
No, in person.
All right, Ms. Ferguson, can you reset this for the week of January 6th, please? All right, you're going to come back on January 7th and you'll need to appear in person, Mr. Andrade.
Andrade.
And next time, no gum chewing.
Oh, I'm sorry.
Thank you.
You're
Thank
welcome.
you.
All right, and whose client is? This the remaining person?
Thank you.
All right, and what's your client's name? All right, so let me, Mr. Acosta, could you say something, please?
Yes, ma'am.
All right, just 1 second, we have an issue. Let me see
Yes,
if I
it
can
seems like there's
go over here and
my
make
feed
sure we
was
can
getting
get
mixed up
audio
with the
from
other.
him. Oh, it's a PSI?
Yeah. I don't know how I got set up for Zoom. I didn't. It should be. He is on a rig in the Gulf of Mexico.
All right, when will your client be back?
I would have to ask him right now, Judge.
It looks like, I'm not sure. Can you hear me?
All right, Norma, this should not be by Zoom.
This opposed, Judge.
Yes.
Okay, so.
So you want to call him and find out when he will be back?
Yes, I will.
Judge, can you hear me?
Let you know that the email's still out.
Okay.
I don't know.
Judge.
Yes. Well, the prop, just 1 second. Sean, can you mute us, please? All right, who's here on Tommy Lopez? All right, Mr. Lopez. Hey, congratulations, you have a graduate.
Yes. What a great day that was.
Oh,
Thanks,
that is
Judge, for
awesome.
moving some cases for me.
Sure. All right, so where are we on discovery?
Your Honor, we, this is the first setting from what I understand. I was told there's video. I don't think that's uploaded yet.
All right, Ms. Ferguson, if I can have a 30-day reset for discovery on Tommy Lopez, please. All right, January 14th.
Thank you, Judge.
All right, thank you. David McNew. Who's the attorney for David McNew?
You can go to the back, Carl.
All right, sir, just have a seat. We'll call you. Oh, all right, David McNew. All right, where are we on discovery?
I'm still reviewing it, Judge. I don't know if there's anything missing just yet. It is his first post indictment setting.
All right, Ms. Ferguson, if you'll set this for 30 days for discovery, you all will need to confer off docket as well. And that will be your discovery date and plea deadline date. Of course, if you don't have all discovery, we'll do something else. What date?
I'm sorry, you said 30 days, Judge?
Yes.
I can do the 16th.
All right, January 16th. Thank you, and thank you so much for dressing appropriately for court.
And Judge, may I very quickly approach?
Yes.
It's,
Is it off docket?
it is.
All right, you'll have to wait,
Okay,
because I have other cases ahead of you.
okay. Can I put in line? There's an
Yes.
agreed order for a bond modification. You want them back?
Yes, please. Thank you. All right, Krista Molina. Yeah, well, okay. We'll do the final MTR, but then everybody else will have to come back the afternoon.
Judge.
All right, court is calling 2024 CR 4065, State of Texas versus Kryistyle D. Molina. Can I have parties announced for the record for the state?
Nicole Thornborough for the state.
Oh, you all need to reverse. For the defense?
Monica Anna Guerrero for the defendant.
All right, and are you Miss Molina?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Molina, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
On count 2 and waiving remaining counts.
Any objection?
No objection.
So your waiving counts
1
1
and
and
3.
3. All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged in count 2 with misapplication of fiduciary property, 2,500 to 30,000?
Yes, Your Honor.
As a state jail felony, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Miss Molina, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain? Do you understand it?
Yes, I did.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. No application for deferred adjudication. State recommends community supervision. There's to be restitution of $10,000 to DZ Industries. And you are not to be employed in the capacity where you handle or control funds that are not your own funds. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes. Sir.
Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Did I proceed to exhibit 1 and its attachments? No objection.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Here's my question. Is she going to be able to pay this $10,000?
Yes, over the next 4 years, that's, she understands that is, yes.
Yes.
She was recently, let go from her job as of yesterday, but she's in the process of finding another job. She's confident she's able to do that. She's always worked. She's has to work to take care of herself, and so she fully intends to pay that restitution.
All right, I'm gonna set this for a PSI, and at this date of this PSI, she needs to come up with half.
Okay,
All right. Set this off for 60 days. All right, February 17th, you need to pay at least half, so that's $5,000. Do you understand?
Yes, ma'am.
And do y'all want a PSI or you want to waive it? Because my concern is her paying the half of this restitution.
we'll do the, yeah,
We're fine either way, Judge.
All right, so she needs to come up with half the restitution on that date.
Okay.
All right, we'll see you back on February 17th.
thank you.
Thank you.
And just to confirm, there's actually no PSI.
No PSI.
Okay, thank you, Judge.
Thanks, Judge.
Jay, yes, Cincy. Jay Gabrielski.
It's mine, Judge. That's the off-docket one.
Yes.
So it's a motion to, which should be included there, a motion to modify bond condition. He's currently on GPS. The states agreed to do tracking only and waive all fees. They've indicated that on the order as well.
All right, is the complainant aware of this?
I did call the complainant earlier today, Your Honor. I called her at about 11 o'clock. I told her I needed to hear with her, from her within an hour, and I have not been with her.
All right, I will tell you, I don't sign these unless,
I'll also give you some background, Judge. You can see the indictment in front of you. This is a continuous violence against the family that got reported in November of 23. It was just indicted. The most recent allegation of violence is 26 months ago.
Okay.
At the time of its reporting, there was a, guess what, divorce custody pending.
okay, all right, so this is what we'll do. I think the complainant needs more time than that to respond. I just want her to be aware. So 2 o'clock,
Yes, Judge.
okay?
Can I check in with the court on your ruling?
Yes.
Okay, because my
You
wife,
can zoom in or
my wife
either.
called, I've got to apparently get
No,
off
no, no.
or something like
No, no, no,
my
Go for it.
father-in-law, so.
sure.
Okay.
Okay,
Thank you, Judge.
you're welcome. Dennis Johnson. All right. The court is going, after this case, the court is going on recess. And everyone else will need to come back this afternoon. Landon Kendrick. Court is calling 2024 CR 008039, State of Texas versus Landon Omar Kendrick. Can I have parties announced for the record for the state
Megan Galloway for the state.
defense?
Arlene Gay for the defendant.
And are you Mr. Kendrick?
Yes.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Landon Omar Kendrick who is charged with possession of a controlled substance, penalty group 1 grams to 4 grams on October 15th, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
The state wishes to proceed on violation of condition number 1 on or about the 10th day of November 2024 in Bexar County, Texas. The defendant, Landon Omar Kendrick, committed the offense of unauthorized use of a vehicle in violation of condition number 1.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion and sentence you up to 4 years in the prison? Knowing that, do you still wish to plead true to violation of condition number one?
Yes, Your Honor.
Court will find violation of condition number one true. As a part of his agreement, it says that no cases will be indicted arising out of 2024 PF 13079. Is this one of those cases?
No, Your Honor.
Judge, so I have pursuant to the agreement, but the case number that I have is 2024 PF 23227.
That's not what the court have. So if y'all want to look to see,
Let me check, just to make sure were these not taken into consideration at the time of?
no, it just says that if there are other cases arising out of that cause number, that the state would not proceed on them. So if you could see, all right, thank you. Oh, did you see that?
It has been.
Defense attorneys are like, please put this on the docket. We're like, okay.
I think every court's like that. I had court on Friday, the 144. So everybody's trying to move those.
Judge, the allegation is.
Oh, I just wanted to make sure that was clear. All right. So the court is finding violation of condition number one true. Is there a proposed agreement?
There is, Your Honor, so we are asking that you grant the state's motion, revoke the defendant's community supervision and reform the judgment to reflect the 2-year sentence in the Texas Department of Criminal Justice.
All right. So what has he done since he's been on probation?
I believe he reported,
I was only on probation
Oh, yeah.
for maybe 3.
I'm sorry, what?
just,
Sorry.
he did report, he was living at the Haven for Hope. And he was beginning it, and this case arose, he borrowed a car. And
Didn't return it?
the person claimed that that the individual claimed that the vehicle was stolen, even though the keys were provided. So there was a big miscommunication. My client, we were given a recommendation and my client opted to take the recommendation. And that is 2 years. He's never been to prison before.
All right, so here's the court's question. Not to go behind anybody's agreement, but state defense is saying that he had the keys to the vehicle and this wasn't really a unauthorized use of a vehicle, that it was loaned to him. Now, sometimes I understand in my experience as a defense attorney, sometimes people will let people use their car in exchange for drugs, and then the person who's using it doesn't return it on time, so then it becomes an unauthorized use. So I'm being told that he had the keys. Is the person saying they left the keys in the vehicle, or?
It's Kirby Police Department, and what the police report indicates is she's claiming that it was outright stolen between a certain time of day.
So based on the report, Your Honor,
Mhm.
it's my understanding it was reported stolen. I think there's some discrepancy and there may be another party involved that did not have, the authorization or consent from the owner. That defendant is under the impression that that person that did not have the owner's consent then gave him that provided the vehicle to him, and he's under the impression from the person that did not have consent from the owner.
Okay. So then is this a revocation case then? I mean, I know you all have come to an agreement, but of course, I'm trying to do what's right.
Mhm.
So,
And we did discuss it, and I think my client really wants to put it behind him.
all right, so here's the thing. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for record.
Landon Omar Kendrick.
All right, Mr. Kendrick, here's the thing. You know yourself, if you're truthful with yourself, you know yourself better than your attorney does, better than probation does, better than the state does, better than I do. So if you want, I'll continue you, but let me just tell you, you're probably going to go potentially in an inpatient treatment because there's going to be another TAP evaluation, and whatever the TAP evaluation recommends, that's what's going to happen. Otherwise, if you want, I'll follow the agreement for you to do the 2 years in the prison. It's completely up to you.
Now, the inpatient would be where we're at.
No, here's the thing.
I just.
These are your choices.
Oh, okay.
And the
Just 2 years.
information,
I'm
and
sorry.
the information I am giving you
The 2 years is fine.
is the information. So you want the 2 years?
Yeah.
All right, the court is going to sentence you to 2 years. And are you waiving your right to appeal?
Yes,
All right, the court is going to sentence you then to 2 years, and the prison give you credit for any time served. And as previously stated, the court found violation of condition number 1 true. Is there anything taken in consideration?
Yes.
And the court will take in consideration 2024 PF 23227.
Your Honor, I just want to state on the record that he has 202 days. I did verify that with the clerk, and I'm sure they'll verify it again. But with Odyssey, the way it is, and the way the dockets are printed and the way the back time is printed is.
So that's the court's rulings. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, ma'am.
All right, I'll order the therapeutic community. We can go off the record. You're gonna have to change your ways. Otherwise, you're gonna find yourself living the rest of your life at somebody's prison or somebody's jail. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right, I think they have the document.
Oh, have you signed it?
No, I haven't,
Oh, okay.
but they have it, so if you
Perfect.
can grab it from the clerk.
I could grab the document. J. Gabrielic. Gabriel.
Oh, do they have it?
They do. Would you like it?
Yes, please.
Okay, and I was able to speak with. I can find it.
All right. So on this case, State, you said you were able to speak with the complainant?
I was, Your Honor, I did let Mr. Alexander know that our complainant is not in agreement with changing the GPS from partial to tracking, but that she did understand why the state was agreeing to do so.
All right, so what's the reason to change it to tracking?
Your Honor, this time the allegations are, I believe, over 2 years old, and he has been not on any sort of supervision for the past 2 years and has had no further incidents other than what was alleged 2 years ago.
All right, and so he's had no contact with the complainant, is that correct?
I don't know if it's no contact, but I have asked the complainant that there's been no incidences that she's had to report to the police or anything, and she didn't.
All right.
Judge, if I
I
may,
guess prior to just recently, there wasn't any sort of no contact order in place.
Okay. Let me see. All right, then I'll follow the state's agreement for the tracking only. All right, anything else?
Not from the state.
All right, thank you.
thank you, Judge. Thank-
Does he have a court date upcoming, Carl?
Let me check real fast because I actually haven't pulled up on Odyssey. Let me see.
All right, just give me a moment.
Here, and I have a setting on January 16th.
Yes, ma'am.
All
January-
All right, then we'll be back on January 16th.
Okay,
All
thank
right,
you.
thank you. But are you ready on your case? Okay. All right, you can come up. All right, court is calling 2024 CR 2928B, State versus Curtis Ray Wilson. Can I have parties announced for the record for the state
Andrew Harris, Salem.
defense?
Bud Rittenhour for the defense.
And are you Curtis Wilson?
Yes, ma'am.
All right, you entered a plea on November 7th to aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. Affirmative finding of deadly weapon. State opposes your application for deferred adjudication. This will run concurrent with 2024 CR 2927B. And the state is taking into consideration some cases. When it says that it's running concurrent,
There are two pleas, Judge.
all right, I don't have the other plea paperwork. All right, and also 2024 CR 2927B. And that cause number, you entered pleas to count 1 and count 2. The state waived count 3. And that's a deadly conduct discharge of a firearm. And according to that plea bargain agreement, punishment is to be assessed at a cap of 10 years. And it's to run concurrent with 2024 CR 2928B. And there are 2 other cases that are being taken in consideration. Have both parties had a chance to review the PSI report and the TAP evaluation?
Defense has, Your Honor.
Any objections to the PSI report or TAP evaluation? State?
No, Your
Defense?
Honor. No, Your Honor.
Any witnesses? State?
No, Your Honor.
Defense, any witnesses?
Judge, we have none to testify. I provided the court a motion I filed this morning with statements from members of the family. We do have 3 members of the mother, father, and stepfather are present in court in support. They're not asking to testify.
All right, any objection to the court reviewing the letters of support?
No, Your Honor.
All right, just give me a moment. Let me review that. And the letters of support are from the defendant's father, former teacher, cousin, stepfather, and mother.
That's correct.
All right, the court has reviewed the letters. All right, state your post.
Yes, sir.
All right, why are you opposed?
Nature of the offense, Your Honor.
All right, defense.
Obviously, we're asking for the deferred adjudication, Judge. We get here in both cases by law of parties and not by direct action by him. Mr. Wilson was 19 years old. In fact, he turned 22 months ago at the time of this offense. He has graduated from high school, actually withdrew from Sam Houston, finished it online, home tutored by his mother. He had just gotten with the wrong people, going places, not questioning where he was going. He and I have talked a great deal since he's been incarcerated. He understands that you can't just pick up with people and go and not ask what's going on. He has some positive plans, as indicated by the letters, for his future. The young man has a good head on his shoulders and a good positive attitude and definite plans for the future. Sending him to prison at this point in his life is certainly not going to do anything for him or society. Giving him a chance on deferred, understanding the full weight of the punishment is pending over his head should he not make it. He's motivated to finish that, get out there, get training, and just become a productive member of society. He intends eventually to own his own business, looking at truck driving and some other things. So he's looking at the future. He's had a lot of contemplation since he's been in custody. He certainly does not apologize, not the right word. He's almost ashamed that he was involved in this thing at the scene. He was a passenger in a vehicle. He knows he shouldn't have been there. We're asking for the court to give him a chance.
State, the defense is saying that he did not know what was going on or what was going to happen. Do you have any response for that?
I've been focused on a bit more in his recent investigation report. With this, everybody makes mistakes. You make a mistake, don't do it again. I got caught up with something because I was with other people. Well, Mr. Wilson doesn't actually acknowledge what mistake it is that he has made. And as far as I can tell, abdicates responsibility for the choices that he made. He got caught up with something because he was with other people. Not, he chose to be with those people. He chose to do what they did. He got caught up. As far as I can tell, Mr. Wilson still refuses to take responsibility for his choices. And as long as he's going to refuse to take responsibility, he belongs in prison.
All right, so I'm reviewing the facts of the case, and in the facts of the case, it says that they were, the person identified him because they knew him from school. He identified which position he was in, and that a person went in with a mask on. So at what point are you not aware of what people are doing? That's what I'm trying to figure out.
The question was about what was going to happen, what was happening at the time when everything is happening. Well, he was with the people, they were going to do something. He went along with it. His mistake was not understanding what was going on, not asking questions about what's going to happen.
So he's saying that
When people, actually there were multiple cars involved in this case. The one that he was in didn't have anybody in a mask. That came out of a different car. He never left the vehicle he was in. He didn't have the firearm.
all right, if he's saying he didn't know about,
Arguing about whether or not the other people had firearms or not in that vehicle.
all right, if he's saying he didn't know about this plan and he wants a jury trial, I'll give him a jury trial. But based upon what I'm reading in the reports, I don't think he's a good candidate for probation.
Let me talk to my client.
Sure. All right, if you'll come up with your client. And just give me one moment to put something in the system. All right. So what is it? Just one second. We're back on the record in 2024 CR 2927B and 2024 CR 2928B. Defense, did you have a chance to confer with your client?
I have, Your Honor, and given the choices we have, we'd ask that you would like to withdraw the plea and get a trial setting.
All right, Ms. Ferguson, can I have a jury trial setting on Wilson? State, how long do you expect this trial to last?
4 days.
All right. You can do March 4th. All right, your jury trial date will be March 4th.
Understand?
Thank you.
Thank you, Judge.
All right, Nathan Montoya. Court is calling 2024 CR 008168, State of Texas versus Nathan Montoya. Could I have the parties announced for the record for the state? Defense.
David Andre Wood for Mr. Montoya.
And are you Mr. Montoya?
Yes, ma'am.
Counsel, you received all discovery. Did you review that with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Montoya, did you sign the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? What are you proceeding on?
Proceed on the lesser included offense of indecency with child by contact on count one. We will
Right now, please.
Count two.
Any objection?
No, Your Honor.
Did you understand you're charged with indecency with child by contact? That's a secondary felony. Range of punishment is anywhere from 2 to 20 years in prison and an up to $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count one. Punishments be assessed at a cap of 7 years in the prison. There's a $1,500 fine. State opposes your application. This is to run concurrent with County Court Cause number 734433, and there's to be Chapter 62 registration. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is, Judge.
State is at the plea.
Yes, sir.
Outside the agreement, the state is asking that there be no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offense is charged, the less included offense is charged in count one. How do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits one and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. This will come back on January 9th for PSI and TAP evaluation, and on that date, the court will enter its sentence. Any other questions?
No, Your Honor, thank you.
All right, thank you. Israel Cortez. So my understanding, you all just need a jury trial date?
Yes, Your Honor.
All right, did you all confer with each of our jury trial dates? If y'all can confer over a jury trial date and let me know.
Sure.
And if y'all also make sure I have an acknowledgement of discovery, please.
Yes, Your Honor.
Yeah.
Judge, I think we have a.
All right, what date?
I think September 9th, Your Honor.
Okay. All right, are there any pretrial motions that need to be heard?
Judge, there was a motion for discovery that I filed and I forgot to print it out. I submitted it to the state. He reviewed it. It appears that there's no objections to it, so I may just send it to the court as an agreed.
Sure.
Motion for discovery. And there's two other motions that I need to print out and approach the court on this case as well. But I believe there may be some other motions filed, none, you know, as the trial keeps going, or the case keeps going on, I may file some more motions, but those three that I filed and notified the state about are the only ones today.
All right, so if there are pretrial motions that needs to be heard prior to trial, just confer with the coordinator on a date and then I'll hear those.
Yes, Your Honor.
All right. All right, so Mr. Cortez, we'll bring you back. We'll bring you back for jury trial on September 9th. That's the earliest I can get you in. We have other trials that are before you. Okay. All right, they're gonna bring you overdressed in whatever clothing you have at the jail, whatever civilian clothing. If you wish to be attired in something different, just let your attorney know. If there's an issue with the clothing exchange, let the court know.
Yes, Your Honor.
All right, is there anything else?
Not from defense counsel, Judge.
All right, thank you.
Thank you, ma'am.
All right, Moses Martinez. Okay, on this one, there's no application, correct?
Correct.
And I wanted a TAP evaluation.
Unaware if it was complete or not.
Yeah, it's been completed. Have you had a chance to review it?
No, I haven't.
State, have you had a chance to review the TAP evaluation?
Yes.
All right, so if you all will step back because the PSI was done as well, so you can get a chance to review that.
I will.
Thank you. All right, Marco Marino. Hello. Hi.
Thank you.
So today is plea deadline date. Are you asking for a jury trial?
We are asking for a jury trial, but there is a problem with outstanding evidence.
All right, what is the issue? What's outstanding?
Initially, I was informed that there was no cell phone extraction done. Throughout speaking with the detective, it looks like there was an extraction done on multiple devices, including laptops and cell phones. There is, I believe, laptops that might be correct.
No, they told me there was 10 devices in total and 10 terabytes of data.
So we have 10 terabytes of data. Right now, it's available for review upon request at the SAPD tech unit. My thought was that would be for defense too, but defense was informed she's not able to do that. So I am working with the detective to get all that data over here.
Okay, why is she not able to do that?
So I have been in communication. I can provide emails if you
No, no,
want
no.
to.
Why- So why are they saying you can't do that?
They are telling me that they, as agents of the state, have to put that in a format that is accessible and affordable to the DA's office to give to me. They cannot make direct contact. I cannot visit. I cannot access it. They are to transfer it to the state.
Oh, it sounds like they're saying they have something that's proprietary.
Yes, yeah. I do know that I'm working.
I think the extraction, the, how would I say it?
The data?
No, whatever extracts the information, whatever it's called, that's proprietary. So when are they gonna have it to you? The actual data?
So right now, the detective has offered to bring it over piece by piece with as large as a device as he can, which is 2 terabytes. So I just need, we were trying to figure out a quicker way to do that. It doesn't seem.
But I know that that was communicated to you, but he has communicated to me in writing that he has no role in that. He had told me that it would be that division and that they told me to talk to the lead detective. So there's been a lot of runaround. My intention is to go to that headquarters today and talk to a supervisor to resolve this matter.
And then what we will do then is we will reset this for the week of January 13th. And who did you speak to?
I spoke with a detective, Travis Gorley. She spoke with a detective, Travis Gorley. He referred me to that tech division. And then there was a clerk who gave me Ashley Edwards's email address. She's the lead detective on this case. I sent her an email requesting follow-up and I have not gotten a response yet.
All right, so this is what we're gonna do. We're gonna reset this for the week of January 13th. And those parties that she's received emails from, they need to be in court on that date. Ms. Ferguson, give me a date. And do we have trial the week of, if you have all of it to turn over to defense, great. If you all do not have that, then these people need to appear. What date?
You said 30 days.
No, the week of January 13th.
That's fine.
All right, so January 16th, if all of the data is not ready to be given to her, then those parties, and if you'll make sure that the state has the name of those parties will need to be here to explain why.
Judge.
All right, thank you. Is there anything else?
Nothing further.
All right, thank you.
Thank you.
Your Honor, I have coach.
Yes. Hey,
Hey, how are you?
all right.
I just presented a couple to your grand jury and need to get a couple of your signatures on some rejections.
All right, thank you. Thank,
Thank you.
are you ready for the holiday?
Oh, I'm not there yet. I'm trying to. How about you? Are you gonna go back home?
Yes,
Oh, excellent.
yeah.
Sure your mom will be very excited to see you.
Oh, yeah, I'm gonna be excited to see her too. You know, to me, that's what Christmas is all about.
Same. Well, especially as I get older, I enjoy it more being able to see
Yeah.
everybody, so.
You know, I was watching this one couple. They have young children, but of course they are all adults now. And they said that when their children were younger, like 5, they started doing scavenger hunts. And it wouldn't be big gifts, but the children would love the scavenger hunt part of it. And he said, then when they got older, we just stopped buying gifts and Christmas was going on adventures and traveling. I'm like, yay.
It seems like an Easter Christmas combination, sort of. You know, like.
Yeah.
So, no, but that sounds fun.
All right, awesome.
Well, if I don't see you, Merry Christmas and, safe travels.
Thank you so much. I still can't believe how old your girls are now.
12 years old.
I couldn't even stand over the microphone and we were just,
They made the tennis team yesterday.
oh, that is
Yeah.
awesome.
So,
Yeah.
they're better athletes than their dads. Take care.
All right, you too. All right, if you all come up. And on what page is Doug Gonzalez on? All right, thank you. All right, court is calling 2024 CR 008-427, State versus Moses Martinez. Can I have parties announced for the record for the state defense?
I'm jumping in from the accused.
And are you Mr. Martinez?
Yes.
All right. You entered a plea bargain agreement, and according to your plea, punishment is assessed at 3 years in the prison. There's a $2,000 restitution amount to Desiree Ruth, ROUTH. And the court ordered a PSI and TAP evaluation. Have both parties had a chance to review the PSI and TAP evaluation, state?
Yes, Your Honor.
Defense? Any objections to the PSI and TAP, state?
No.
All right, so after reviewing the PSI report and the TAP evaluation, state, do you still wish to proceed with the agreement that was tendered?
State change its offer to silent on an application for community supervision.
Any objections to that?
No objection to that, Your
All right, so here's the thing, Mr. Martinez. I can do one or two things with your case. One, I can follow your agreement, the 3 years in the prison. But I will tell you right now, if I were to grant your application, I would not feel comfortable with you being on bond during the holidays. So you would be at the Bear County Jail. Felony drug court does not open up its ability to accept new people till the end of January. So if you want the court to consider an application for probation, I will. But that's what I would consider. End of story. There is no, but can I do this? But can I do that? That's the only way that I would consider giving you probation. And let me just explain to you why I wanted the PSI and the TAP evaluation, because I see that your history is riddled with DWIs, right? 3 years, prison. Maybe they'll help you with your drug issues with alcohol, maybe not. But I do know once you're released from prison, then there will be really no supervision. So those are your choices. And if felony drug court does not take you, then you will be waiting there for another evaluation for perhaps lifetime recovery. Those are your choices.
Can I show you some paperwork here? Look, I have attended college. Look, I was in a car accident. That's why I didn't finish my
All right, so I understand what you're telling, but I want you to hear me.
Yes.
You only have two choices. Either you're going to prison for 3 years. When you get out of prison, there's probably not going to be any supervision, or either you're going into custody today and felony drug court will review you for their program at the end of January because they don't have any room for you. I do not feel comfortable granting your application for probation and allowing you out and about for the holidays. So those are your only two choices. Either it's prison for 3 years or either it's probation with the conditions that I'm going to give you. So do you need to discuss that with your attorney?
So I'm gonna be locked up right now to win.
Oh, if felony drug court accepts you, great. If they don't accept you, then you're gonna go into some inpatient treatment.
And what about that mental program on County Court 12?
No, this is a felony.
This is felony, this,
Yes.
well, I guess I'll take a chance in the county.
All right. So, well, when you say take a chance in the county, what do you mean?
Well, this, you said I'm gonna be there in the county jail, see if I apply for that probation, right?
Yes.
Yes, that's what I want.
So you do not wish to go to prison?
No.
All right, then counsel, I'll need you to fill out an application for community supervision and we'll go from there.
Yes, ma'am.
And if y'all can change your plea bargain agreement to the state is silent.
Your Honor, I have a question. How long more or less will I be in there?
All right, so see, here's the thing.
This is what I'm ready for.
Let me just tell you something. This is what I noticed. I noticed that when people are looking at prison, they will say they will do anything not to be in prison. And then when they're given a chance not to be in prison, then they want to write different things.
Yes.
So, I mean, you'll be in there as long as they require you to be in there. That's how long you're going to be in there.
Okay. But I can change it right now, right? The prison time.
Oh, okay. He wants prison time.
I
You
really
can stop. He wants to go to prison.
No, that's okay.
Nope. We're gonna do prison time. All right, that's what he wants. Could I see the paperwork? He's decided he wants to do prison, so I'm gonna follow your agreement. I know, to the family, sometimes people want to do what they want to do. So the court is going to sentence you to 3 years in the prison, give you credit for any time served. There's a $2,000 restitution to Desiree. Desiree Ruth, Routh. There is a 2-year driver's license suspension. All right, is there anything else with regards to sentencing? And let me see, I don't have his trial court certification, counsel. For some reason, it's not a part of the packet.
It's in the file. I can fill out another one.
All right, thank you. And also add the therapeutic community.
People with them. You want to get ready for the time I was locked up?
Yes, legally, I'm required to give you that. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you.
Thank you.
Thank you, Judge.
You're welcome. All right, who's here for Bailey Corley?
I am Judge.
All right. Thank you for your patience. Bailey Corley. Court is calling 2023 CR 2218 State versus Bailey Alexander Corley. Could I have parties announced for the record for the state? Defense.
Robert Porter.
And are you Mr. Bailey Alexander Corley?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Bailey Alexander Corley who was placed on deferred adjudication in 2023 CR 2218 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on June 21st, 2023 for a period of 4 years? Is that you? All right, state.
Judge, we wish to proceed on violation of condition number 38 on or about the 13th day of November 2024 in Bexar County, Texas. The defendant Bailey Alexander Corley did then and there failed to attend and successfully complete the Bexar County PSDD substance abuse outpatient treatment program in violation of condition number 38.
To that violation, how do you plead? True or not true?
True. We waive and abandon the remainders, Your Honor.
No objection.
All right. Did you understand by pleading true to violation of condition 38, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 38? Court will find violation of condition number 38 true. Is there a proposed agreement?
There is not, Your Honor. And so the state is asking that you deny the state's motion and continue him, but order him to status and upon release from status of felony drug court.
All right, in defense, what are you requesting?
Your Honor, we do believe he does need drug treatment. We're asking the court to consider lifetime recovery. He does work. I understand we just pled to, he didn't finish outpatient. However, he went for like about a month and a half, had issues getting there. They let him start again. He showed up the next day. He had pajama bottoms on instead of dressed properly and terminated him at that. But he understands he does have a drug issue. He wants to address that drug issue, but he also wants to continue working.
All right. Probation, what is your recommendation?
Judge, the recommendation on the court summary is for Saturn.
All right, any objection to the court reviewing the court summary?
No objection.
Oh, I have it online, yeah. Thank you. All right. So, Mr. Corley, here are your choices. You can do inpatient treatment with SATA, or either if you would like, I can revoke you. And I will sentence you to 3 years. All right, the court will deny the motion. Alternate amend conditions to include SATA. All right, is there anything else who needs probation? Anything else you need from the court? All right, good luck to you.
Take care.
Thank you.